Good morning, this is your Kelso Report for Friday, January 13th. I'm your host, Clark Kelso. We start with two California Supreme Court decisions today, the first in the area of products liability. One of the problems in a products liability area has been that the individual parts in products are usually made by different manufacturers, and the ultimate product is the result of a combination of products. Now, it's always been clear that the final product manufacturer, that is, the company that actually assembles the whole product, is clearly responsible for the entire product and all of its component parts. And similarly, if a product defect is traceable to a component part, the manufacturer of that part may be held liable. In O'Neill v. Crane, the California Supreme Court yesterday faced the question of whether one component part manufacturer can be held liable for injuries resulting from defects in another part of the product which was manufactured by a different company. The court framed the issue as follows. When is a product manufacturer liable for injuries caused by adjacent products or replacement parts that were made by others and used in conjunction with the defendant's product? Factually, this case involved valves and pumps that were manufactured by the defendants, which had been wrapped in asbestos, produced by a different manufacturer, where the asbestos was added after the valves and pumps had been delivered to the primary manufacturer. The plaintiff sought to hold the valve and pump manufacturer liable for deaths resulting from exposure to asbestos on the ground that it was foreseeable workers would be exposed to and harmed by the asbestos in replacement parts and products used, quote, in conjunction with, close quote, their pumps and valves. In an opinion by Justice Corrigan for a unanimous bench, the court rejected the in conjunction with test and held that a product manufacturer may not be held liable in strict liability or negligence for harm caused by another manufacturer's product, unless the defendant's own product contributed substantially to the harm, or the defendant participated substantially in creating a harmful combined use of the product. In other words, absent a showing of causation traceable to the defendant's product, or evidence of joint manufacture, there is no liability. Our second case involves criminal procedure with juveniles. The United States Supreme Court held in Davis v. United States in 1994 that once an adult suspect has waived his Miranda rights, any subsequent assertion of the right to counsel must be articulated, quote, sufficiently clearly that a reasonable police officer in the circumstances would understand the statement to be a request for an attorney, close quote. A similar clear articulation standard applies to the right to remain silent under the Supreme Court's recent decision in Burgess v. Tompkins. Now yesterday, the California Supreme Court held in People v. Nelson that these same standards apply to a juvenile claiming a post-waiver invocation of Miranda rights. The post-waiver statements, then, must be sufficiently clear so that a reasonable officer would understand the juvenile to be asking for an attorney or to remain silent. Factually, this is a tough case, where a 15-year-old was subject to a lengthy interrogation and, after a few hours, started asking to speak with his mother and other relatives and asked to be left alone. According to the unanimous California Supreme Court, a reasonable officer would not have understood these statements to be clearly and unequivocally asserting his Miranda rights. The problem, of course, is whether we should expect a 15-year-old to know how to clearly and unequivocally assert his Miranda rights. It will be interesting, I think, to see if the United States Supreme Court takes up this case, given that court's interest in recent years in whether criminal procedural protections available to juveniles should be the same or different than the rules applicable to adults. Now we have three Ninth Circuit opinions to take a look at. The first involves criminal procedure and lawyer ethics. Government lawyers have an obligation to litigate vigorously, like all lawyers. But government lawyers have a special obligation to litigate fairly. As Justice Sutherland famously remarked, Federal prosecutors have a dual obligation to strike hard blows, but to refrain from striking foul ones. Well, the Arizona Assistant U.S. Attorney in United States v. Lopez Avila crossed the line into foul territory. In a drug prosecution, the key question was whether the defendant had been threatened and coerced to bring drugs into the United States. She testified that she had been threatened. The prosecutor tried to impeach her testimony by reading back supposed testimony from an earlier change of plea hearing before a magistrate. What he read back seemed to contradict her statement that she had been threatened, but that was only because the prosecutor had deliberately omitted language from the transcript. As part of the prior plea hearing, a magistrate asked the defendant, quote, "Has anyone threatened you or forced you to plead guilty?" To which the defendant answered no. Perfectly ordinary question for a plea hearing. Well, the prosecutor told the court and then read to the defendant in front of the jury the following modified version. Quote, "Court, has anyone threatened you?" Defendant, "No." Close quote. Well, as modified, it of course made it sound like she was conceding she had not been threatened to carry the drugs. But it was perfectly clear that was not the intention of the question at the plea hearing. Now, at a break in the proceedings, the defense counsel asked the prosecutor for a copy of the original transcript, where the prosecutor's deliberate effort to mislead was then discovered. The district court immediately granted a mistrial at the defendant's request. The defense then said, well, double jeopardy bars a retrial, and the district court in the Ninth Circuit, of course, held that the double jeopardy clause does not apply in these circumstances. Prosecutor misconduct, which leads to a defense requested mistrial, does not trigger double jeopardy, absent proof that the prosecutor was deliberately trying to goad the defendant to make a motion for mistrial. Well, there was no such proof in this case. There was only proof that the prosecutor was trying to secure a conviction through grossly improper and misleading means. Now, the Ninth Circuit suggested on remand that the district court should consider a dismissal with prejudice for prosecutorial misconduct, or that the district court should consider disciplining the prosecutor directly, or that the Department of Justice should itself investigate the prosecutor's misconduct. This lawyer's in a heap of trouble. And there is really a good lesson here for all government lawyers. You really shouldn't be going as far as this lawyer did, dropping language out of a quote to deliberately mislead. That's just not fair litigation practices, and it's not professional. Our next case involves class actions. Now, as you know, the United States Supreme Court has, in several recent class action cases, tightened the requirements for certifying a class. The Ninth Circuit's decision yesterday in Mazda v. American Honda Motor Company appears to me to be driven a bit by that tightening. The plaintiffs were trying to certify a nationwide class in a suit against Honda, claiming that the advertising and marketing of Honda's collision mitigation braking system misled buyers about its true capability. The trial court decided that California's consumer protection laws, including the unfair competition and advertising laws, could apply to all class members, since California's laws did not seem to be materially different from the laws of about 19 other jurisdictions, which included those class members. Over a dissent, the Ninth Circuit panel reversed, concluding that there were in fact material differences in the law, based on particularly different requirements for scienter and reliance, and that California law therefore could only apply to California purchases. And that accounted for only about 20% of the class members. Having decided that California law did not apply, the panel concluded that individual questions would predominate, since not only would different law apply to class members' claims, but the evidence showed that different class members saw different advertisements and marketing materials. So the majority held that a nationwide class was inappropriate and reversed the trial court's class certification. The court did make it clear that on remand, the district court could try to define different classes, and maybe that would permit the case to go forward as involving separate subclasses. Final case involves age discrimination. The Ninth Circuit faced in Shelley v. Guerin a garden variety age discrimination claim in a failure to promote context brought against the Army Corps of Engineers. The district court had granted the Corps' motion for summary judgment based on its conclusion that the plaintiff put forth insufficient facts that his age was the but-for cause of his non-selection for promotion. The district court did not employ the burden-shifting analytic structure established by the Supreme Court in McDonnell Douglas v. Green for employment discrimination claims. Since it believed a more recent decision by the court, Gross v. FBL Financial Services, made McDonnell inapplicable to age discrimination claims. The Ninth Circuit reversed. First, the court held that the McDonnell framework still applied to summary judgment analysis, and that Gross, which involved the question of burdens of proof during trial, had explicitly noted that its decision did not answer the question whether McDonnell still applied at a summary judgment stage. Second, under the burden-shifting analysis of McDonnell, the Ninth Circuit held that the plaintiff had in fact established a prima facie case of age discrimination, and that disputed questions of fact then still existed about whether the Corps' explanations were pretextual. The case is remanded to the trial court for further proceedings. Now, the court's decision here might give the Supreme Court the opportunity of resolving the open question from Gross, whether McDonnell still applies in a pretrial context, although I don't see here a really burning need for Supreme Court intervention, so my guess is they'll leave this case alone. That's it for today's Kelso Report. Have a good weekend and a great day in the law.